Yeah, I mean, there was a key moment in it's called the Casey decision. It was a case that came out of Pennsylvania, where we had the same kind of turnover that we saw with the three Trump appointments. So the two most liberal justices on the Supreme Court, both ardent supporters of Roe versus Wade, were Justice Brennan and Justice Thurgood Marshall. And now, while Brennan was appointed by a Republican, he was probably the most liberal justice we had. Both would have wanted to be replaced by Democrats and by other liberals, but that's not the way it works, as we found out in 2020 with Justice Ginsburg. Justice Brennan was sick, had to retire. Justice Thurgood Marshall was sick, both replaced by Bush. And we ended up with a very strong Republican majority, and everybody expected, okay, you've got Brennan and Marshall gone, replaced by Republicans, and Republican presidents have been promising for 50 years that they would nominate justices who were opposed to Roe versus Wade. It's kind of their signature policy position. So everybody thought it was there, but behold, it wasn't, because what you had were three Republican justices, Souter, O'Connor, and Kennedy, who, feeling this pain, this pressure about whether to overrule a case that has such a strong identity, crafted a compromise. Now, it was a compromise that, they hoped it would work, and I guess I really, in some ways, it didn't. They said that we will reaffirm the essential holding of Roe. So this was a 5-4 decision that maintained Roe versus Wade in 1993, when, that at that point it would only have been 20 years old, but it was still, as they said in the opinion, we have a whole generation of women who have grown up with this right. And that was in 1993. Now we've had 2.5 generations of women who've grown up with this right. And they said, we're going to keep the essential holding, but we're going to get rid of this odd trimester framework that the original Roe decision had. And they said that the state always has an interest in preferring life. And we're not going to sort of say they have no power at all for the first trimester, and then it's sort of balanced in the second trimester. And then in the third trimester, the state's interests are predominant. And I think they kind of hoped that the American people would sort of accept that it didn't work. I mean, what happened is it became clear that the states could regulate abortion, and they tried so many different ways to do it. I mean, the last 10 years has been just a litany of kind of creative, strange ways to try to limit abortion rights. So some of it was approved in Casey, such as 24-hour waiting periods. And what the Supreme Court said then was, okay, states, you can regulate abortion as long as you do not create an undue burden. Now, everybody said, what's that mean? And we know Justice O'Connor was sort of the person who thought this was a test that would work. And the truth is, yeah, I don't know exactly what an undue burden is, but it is so much like so much of American constitutional law. Case by case, we'll figure it out. And we talk about Roe versus Wade and Casey together because Casey really is the law of the land, not Roe. And Casey did change some of Roe. And Casey was always focused on viability. Viability is the point in time when the child can, and that's where the language, it's always a child if you're against abortion, and it's a fetus if you're pro-choice. So I'll probably use those words interchangeably. Once the child can survive outside the mother's womb, that the Supreme Court has said is the key moment. A woman should be able to get an abortion up to the point of viability, without any undue burden imposed by the state. And that's typically, but the trouble with this, that changes with the medical advances. So what viability had been 26, 27 weeks at the time of Roe, it's now 23, 22, and in some extraordinary cases, even less. So and so what John Roberts said in oral arguments in the case, the Chief Justice, is what's so magical about viability? So he was signaling, and you got to be careful with oral arguments, but I think in this case, this is exactly what he will write, and probably a dissenting opinion is that what Mississippi's doing is consistent with the Casey way of thinking. It's still permitting an abortion within 15 weeks, And for the vast majority of women, that's well within time that they do it. And for those who aren't, they should be able to do it in time. So they are not establishing an undue burden. And he's going to say, I'm going to reinterpret the KC Roe line of cases to say, we don't need this focus on viability. That's not a logical, useful point. And so he would have upheld this. Now, I think, why can't he get another justice to do it? Maybe he is. Maybe Kavanaugh, and that's the one everybody's thinking about. Maybe Kavanaugh is, in fact, considering that, at which time that would be what we call a plurality decision. No one opinion getting 5 votes, but you would have the 3 liberal justices saying this is clearly unconstitutional under Roe and Casey, because it doesn't permit abortions up to 21 weeks, up to viability. So strike it down. Strike it down for that reason. You would have 4 conservative justices saying, well, we're going to uphold it because we're going to overrule Roe, so they of course can do this. But the deciding opinion would be 2 justices, Roberts and Kavanaugh, saying this is okay. Yes, it doesn't permit abortions all the way up to the point of viability, but we don't think that's essential under our now revised Roe Casey decision. I think that wouldn't work, because then, okay, the next day, some state's going to do 14 weeks or 12 weeks or 13 weeks or do something else, and we'd be back in the Supreme Court in a matter of minutes. I mean, the judicial equivalent of minutes would be next year or so. Right. So I don't think that line would hold. It would just be, as we say, kicking the can down the road. But this is obviously going to be a case that is divisive. There's going to be different opinions. And it gets assigned, whoever the senior justice assigns it to whoever he wants. And if we're right, if what most people are thinking, that Roberts is not in the majority, that means it was Clarence Thomas who assigned it. And assigning it to Alito makes perfect sense. This has been a huge issue for Alito. He's written dissents before. There's nothing shocking. I mean, everybody seems to be shocked by the language. Just go back and read his dissents, and it's the start point. It's a lot longer now, and there's lots of points of criticism, but this is exactly what I would expect Justice Alito to write. And okay, he's got to get 5 votes. He may not have it, and it's quite, he may have gotten, I'm sure he got Clarence Thomas, who joined right away. That's the lingo in the Supreme Court. I agree. He probably got Amy Cohen Barrett. Kavanaugh probably said, sometimes what they say is, I'm going to await further writing, which means I want to read Roberts' draft. Now, Roberts' draft hasn't been leaked. He may not have it ready. I don't know. We know for sure the 3 liberal justices are dissenting. I would bet you any amount of money with pretty good long odds. So there's no question we've got 3 justices who are dissenting. They have the oral arguments, and then on that Friday, they have their conference where it's just the justices. And my guess is he had 5 votes. There were 5 votes, but that's not binding. And so Kavanaugh said, yeah, I'm voting to overrule it. But, then the opinion comes out, and we're speculating, but I think it's a pretty good speculation. He reads it, his clerk reads it and said, well, man, this really is a big deal. I got to think about this. So he doesn't join right away. That happened a lot. I was a Supreme Court law clerk for Justice Byron White, who actually dissented in Roe versus Wade, always dissented. And he was a Democrat. And I remember once we circulated an opinion I was working on, and Justice Rehnquist joined it, and I don't remember, but maybe one other did, but we didn't get 5. And we went back and we wrote it. Actually, we went back and took my original draft, which Justice White didn't like, and we circulated it, and eventually got 5 votes. So it's, this happens, and especially in a case like this. We've had another moment like this in the past. It wasn't a leak of an opinion, but it was a tell-all book, The Brethren, which came out in, I think, 1980. And I read it voraciously. It was a year before I clerked, and it had a tremendous impact. The justices felt betrayed. Justice White, again, who I clerked for, I asked the clerks who preceded me, how was the year? So it was great until The Brethren came out, and then he didn't talk to us for a month, because he felt that it was so betrayed. He came off well in the book. He came off as a smart, somewhat curmudgeonly guy, but that's who he was. And but it was clear that everyone said, "Oh my God, these clerks leaked all this stuff." And what we found out is, no, it wasn't. It was Potter Stewart. Potter Stewart was the main source. Yeah, but that's different. That's talking to reporters about prior decisions and court processes. To leak something, an opinion before it comes out, it just goes against sort of everything about the process for how the Supreme Court justices decide opinions. And you're concerned. You're concerned. You can, if a big decision came out about some company that could impact stock prices, so maybe it's, I don't know, some people are shocked by something that never happened before, but I'm not. I mean, as a clerk, this is inconceivable that you would do this. Everyone believes that probably Roberts is not wanting to overrule Roe versus Wade. And we know that actually from the oral argument. He signaled it very clearly in the oral argument. His view was, okay, what Mississippi's doing is saying no abortions after 15 weeks. The vast majority of women get an abortion within 15 weeks, and those that don't probably could. So this does not deny the right. But why would this be unconstitutional under Roe versus Wade and the Casey decision? Because they focused on viability, this point at 21, 22, 23, 24 weeks. And what Roberts is thinking, and certainly he said this in the oral argument, is, okay, what if we just get rid of viability as the benchmark, as that key moment, and just say, hey, look, as long as a woman's right to get an abortion exists for the majority of women in normal circumstances, that's okay. And so he is willing to uphold the Mississippi rule by saying, I'm going to keep the essence of Casey and Roe, but just get rid of this singular focus on viability and say, this is not an undue burden. The vast majority of women can get an abortion within the 15 weeks. The question is, can he get another justice? Because if he can get Justice Kavanaugh, well, then they only have 4 votes to overrule Roe versus Wade and Casey, because we know that 3 liberal justices are dissenting, at which time we have this plurality decision where, we uphold the Mississippi 15 weeks, but we change a key part of what is the accepted current law about Roe and Casey, which is this viability issue. Now, is that will that work? If Roberts can get another vote and everybody thinks it's maybe Justice Kavanaugh, for me, it's like, okay, you have delayed the inevitable for a short period of time, because the next state, the day after this, is going to go to 14 weeks or 13 weeks. They're going to put some other, we know the states are very active. The states in the pro-life states are very active, and they'll just keep pushing it. And, I don't know if Chief Justice Roberts' center will hold. I don't think it will. I don't think that would hold. But it would temporize. It would not result in Roe being actually overruled. It would be significantly modified. When I clerked on the court, which was in 1981, there were a couple of what we called swing justices. Justice Kennedy was perhaps the ultimate in swing justices. One year, there were 24 decisions that were 5-4. Justice Kennedy was in the majority in every single one of them. He was 24-0. That's a baseball game. That's a great baseball game. He said he didn't like the term swing because he makes it sound like he's changing his mind. His view was the rest of the court was swinging, but that's Justice White, who I clerked for, unpredictable vote. He was open to it. He did not have, these sort of litmus test issues that you could predict. Justice O'Connor, another great swing vote. She was a very practical justice. And maybe that's the difference. Justice White and Justice O'Connor were both sort of pragmatists. The question was often asked, how's this going to work? And today, with a lot of the conservative justices, they're originalists. I don't think they think about the question that way. How's this going to work? So the famous affirmative action case from Michigan, which they thought they were going to overrule the Bakke affirmative action and sort of can't ever do it. Justice O'Connor was the key vote in upholding that, and we know that she was swayed by a lot of opinions by amicus briefs, companies, Army officials who said, we really need to have these affirmative action programs. We want a diverse officer corps. We want a diverse junior management people in our company. And that made a difference for her. And the other big case that's up there in the Supreme Court going to be argued next year is the Harvard case and the UNC case that raises the very question, are we going to strike down and overrule the Grutter decision, so that there's no affirmative action allowed in the United States, which is not quite as big as Roe, but it is another very fundamental enshrined constitutional provision that I think certainly is at risk. And this one, that one, Chief Justice John Roberts has very much on record as being opposed to affirmative action and preferring what he refers to as the colorblind Constitution. So, your question is a good one. Are we to a point now where it's all just, you're either on this side or that side? This court is more divided ideologically,
Yeah.
and it sure feels like politically. Now,